Thank you very much for this kind introduction. As you heard, I'm a Polish lawyer, and I'm going to tell you today about the principles of advertisement in Poland. The same as Evangelos and Andrzej Parka, who were before me, I'm the next person from CCB, because as all of you, or maybe not of you, but I would like to inform you that Turkey is also the very active member of CCB, and we are very pleased to have you and to continue our very intensive work with Turkey within CCB. We had some projects together. I participated also, and it was mainly last year the project on training, which was spread out all over the country, over the Turkey. Let me start with some introductory remarks regarding advertisement. First of all, talking about promotion of our profession, we have to talk about specificity of the legal profession. We are not as all other entrepreneurs like butchers, like florists, like any other ones that who can promote freely themselves and advertise. And we have to take special care about dignity of our profession when promoting ourselves on the market. And then I will talk about advertising of Polish legal advisors and advertising of Polish advocates. In Poland, just for your information, there are two professions of lawyer. One of them are advocates, very like traditional one profession as everywhere else, and something which is specific for our country. There is the special profession of legal advisors. The legal advisors are fully recognized at the European level and are on the list of European lawyers. And the only difference between those two professions there is such that by the tradition, legal advisors concentrate mainly themselves on business cases, and they do not have the right till now to defend clients in criminal cases. This is the situation of division of two professions was typical for all former Soviet Union countries. My country belonged to this. Each state-owned enterprises had their own in-house lawyer, and from this profession, the legal advisors was created, and now it is absolutely fully independent profession. The legal advisors have the right to appear in any kind, in all instances of courts, and they have the partnerships and common. They act commonly with advocates. There is no difference. And there are some possible future developments. We will talk about this later on within the enterprise, and I would like to show you some European background in the issue of advertisement. First of all, please note that we lawyers have certain missions. Mission acting in the public interest, this is the first, then protecting rule of law and fundamental principles of democratic societies, then the interest of citizens and justice, and after all those, there is the protection of interest of our client, which is quite low, because we have to act first of all in the public interest and in the interest of, as I said, democracy, rule of law, and justice. And then our other obligation is to provide services on the highest possible level. That it means to educate ourselves all our life, not only before being admitted to the bar, but afterwards also to continue legal education. Sorry. And I would like to say that the advertisement or promotion of our activities, it is nothing else than to think and to fulfill the expectations expressed in core values of the profession. And I decided to present to you those core values just as the kind of reminder, because doing any promotion of ourselves, doing any advertisement, we always have to remember about those core values, and this will be the best key to fulfill all restrictions and all requirements of proper advertisement of the profession. The first core value is independence of lawyers. The second, to keep clients' matters in confidence. But we have to remember that confidentiality is not our privilege. This is the privilege of our clients. Sometimes we say, oh, we as lawyers have the privilege of confidentiality. But this confidentiality privilege has not been established in our interest, but in the interest of in public interest. Then avoidance of conflict of interest, and now something very important for advertisement and for promotion: the dignity and honor of the legal profession and the integrity and good reputation of the individual lawyers. We always advertising and promoting ourselves, we have to remember that we build the impression of our profession, that we are something different than any other businesses. We have to remember about our dignity, about the honor of the profession, and our reputation. If we will remember about it, I am sure that none of us will violate the principles of proper promotion of the profession. Then obviously loyalty to the client, then fair treatment of clients in relation to fees. If we are fair in this aspect, we do not misuse sometimes the situation that somebody is forced to use our services. Then our promotion in this aspect will be also in accordance with the requirements. Then lawyers' professional competencies, as I said before, the issue of education, respect towards professional colleagues. Sometimes people promote themselves, but they damage the colleagues' interest. And we should remember about this principle as one of core values principles of the profession. Now, I already informed you about the specific situation in Poland, that there are two legal professions, and that there are, each of these professions has different rules regarding advertising in each part. I would like to start with legal advisors. As all professions of lawyers in Europe, we have our code of conduct, and in Title V there are the provisions regarding this issue. Since 2007, advertising and marketing of legal services is not forbidden. Before that, we have very strict provision in our code of conduct that any advertisement is forbidden. Nowadays, in our regulation, the word advertisement is not used at all. We talk about the information, and I would like to underline again, we are treated, comparing with the other profession of lawyers, that for them advertisement is forbidden, for us it is allowed already. And, our code of conduct was changed, as I said, in 2007 under the influence of the European Union law requirements. There were very strong requirements, especially from anti-competition authorities, that they wanted that any limits within advertisement will not be enforced anymore. And this was one of the reasons that legal advisors in Poland, they change their code of conduct in this aspect. But again, I would like to repeat, the word advertisement is not used in our code of conduct. We talk about information, and also there is not the very the closed list of the information which can be given to the client. Those are only the examples. Now I have to go a little bit into details and tell you that it was about the past, and now liberalization, as I said, from 2007, and legal advisor. There's information on performance of profession is a right of legal advisor. The lawyer may attract clients regardless the form of practice. We provide our services, legal services, in various forms, like sole practitioners, like in companies, like in-house lawyers. Then the lawyers have the right to advertise themselves, let's say, inform the public about their existence and their specialty, regardless the form of practice. The information shall conform with provisions of law, good manners, and professional dignity. This is what I underlined when we were talking about the core values of the profession, that, you know, that the respect for dignity and also for provisions of law. The provisions of law, those are mainly the provisions regarding unfair competition. The same as everybody, in each country we have the law on unfair competition and what kind of acting is forbidden, not to damage the other business people. And just to respect those rules. What kind of information we can place in various places on our website or in the address book, in the telephone books, in our letterheads. Personal data of a lawyer with picture, professional curriculum vitae, professional and academic titles, confirmed professional and additional qualifications, knowledge of foreign languages, preferred areas of professional practice, logo of the bar, logo of the firm also, and form of the professional practice, in what form we provide the legal services. Then, the amount of professional insurance, the guarantee which we can give the client, and also other activities of a lawyer, plus the information on the fees. I would like to underline that in code of conduct of the other profession of lawyers in Poland, they do not have the right to publicize the information on professional insurance and on the fees unless they are specially requested by the client. It seems to me, for me, a little bit strange, because the professional insurance, this is something which with very important, very important information for the client. We think, as Polish lawyers, that the information about our services is not only in our interest, but it is also in the interest of the public, because it is so important for people to know where they can find the proper lawyer for his or her case, who specializes in certain field, who not. Talking about specialization, I have to inform you that in Poland we do not have this solution specialist, but we can talk about the preferable fields of providing services. What is forbidden, what is prohibited for us? Cooperating with paid agents. We cannot hire anybody, the same the other profession also, we cannot hire anybody who will try to find the clients for us and we will pay to him for this. We cannot formulate the information about ourselves, about our offices in the way which would be contrary to the law or good manners. The very important, as I said before, that the information has to contain the facts and not be misleading, because sometimes the information are not very clear and may mislead the client. And also, using any information, we need to think about professional dignity of lawyers. The other thing which is forbidden, this is we cannot give the clients unreliable promises or guarantees, because sometimes lawyers, who want to attract clients to themselves, they give, like the promises that they cannot promise, because the justice does not depend on them. This is like the old chain of people, the court and so on, that they cannot promise anything. But to attract the client, they do sometimes. By the occasion of performance in mass media, if the information is beyond necessary. Sometimes, as lawyers, we have a chance to show up ourselves in the media, and then we shouldn't use this opportunity as the promotion of our services. We should concentrate on the topic and not use it for wider campaign of promoting ourselves. The other issue which is forbidden, this is listing of clients who do not agree for such activity. It is quite popular that lawyers writing to the client or on their website, they put the list of the clients they performed services in the past. This is also forbidden unless the client gave very clear consent to do this. Taking part in rankings organized with violation of rules published by the bar. In general, in our bar, we permit lawyers to participate in various rankings, mainly organized by newspapers. But we, as the bar, we issued the resolution in which we said that there are certain requirements of such ranking when the lawyers have the right to participate. First of all, it should be all lawyers should have access to take part in this campaign, in this ranking. Secondly, there should be very strict conditions and very strict questions to be answered. Like, for example, how many lawyers do you have in your law office? It should be clarified whether we are talking about graduates, whether we are talking about trainees, or exclusively about the qualified admitted lawyers to the bar. Because then the picture can be changed, and some people like to manipulate with this information and in this way to show them much higher than they should be. So 5 minutes, yes. And then sponsoring incompatible with the rules established by the bar. Also, our bar passed a resolution on sponsoring. Just the principles of sponsoring and announcing the fact of sponsoring are very strictly defined in our resolution. As I mentioned, there is the other profession of lawyers, advocates. They have also their code of conduct, and in general, in their case, advertisement is forbidden. But if you go into details, you have the list of information which can be provided, the clients can be provided with. Then I wouldn't say that there is any special difference in the advertisement rules. And before I finish, I would like to show you a little bit of the European background, in which countries, what is the situation in this issue. Regulations on advertising are included in the National Code of Conduct, which is obvious. Advertising and marketing of legal services was forbidden in all Europe before, and in the 90s they started, certain liberalization in this issue. The common rules, advertising should, all over the Europe, advertising should misguide clients, should be strict and factual, prohibition of comparison and with other lawyers and any kind of evaluation of the other lawyers, should protect dignity of the profession. Prohibition of the disclosure information about other clients and other cases, and mailing or other direct contact with the client who do not expressly wishes such contact, because some people send emails to them and offers and so on to clients, and this is very tiring and this is not in our profession. And what we found, analyzing the codes of conduct, that advertising is permitted, with obviously some restrictions. In Austria, Belgium, Czech Republic, Denmark, Finland, France, Germany, Iceland, Ireland, Latvia, Lithuania, the Netherlands. In Netherlands there are no restrictions at all. Norway, Poland, regarding legal advisors, Sweden and Turkey we have on our list. And then advertising is prohibited, but information is permitted. In Italy, Liechtenstein, Poland, advocates, Slovakia and Slovenia, and Malta is the only country where any kind of advertising is strictly forbidden. Just one last sentence. I would like to quote to you the CCBE Code of Conduct regarding the advertisement. A lawyer is entitled to inform the public about his services, provided that the information is accurate, not misleading, respectful of confidentiality and other core values of the profession. If you fulfill those three requirements, then you don't need to be afraid to violate the principles of the advertisement. And the very last remark, I was invited by Canadian Bar Association some years ago. I spent some time there. And they had the lecture for the lawyers about the advertisement. And I always will remember the words of the person, the lecturer. He said, the best advertisement is good opinion of one client. The client who was satisfied with your services will bring 5 next clients. Thank you very much for your attention.
Sayın Slazak'a bizler için ufuk açan konuşması nedeniyle teşekkür ediyorum. Şimdi söz sırası İspanyol meslektaşımız Marta İsel'de. Buyurun.
Thank you very much, and thanks again for the first time for inviting me and letting me participate in this Lawyers' Day in Turkey, where I've been feeling always in Turkey like at home because of your hospitality and your kindness. The thing is that I have not a lot, or at least nothing to add to what Maria has been saying, because I think she said everything. Even the code of conduct of the CCB, which is the code of conduct at European level, I think there are 18 countries now that have been adopted. But just let me say a few things. Advertising and publicity historically has been prohibited to our profession, at least till the authorities of the free competition get into our profession that was really very self-regulated. By 1986, the England and Wales Law Society were the first to open lawyers to be to have that chance for the advertising and publicity of their own activity. Later, around 1990s, it was the time for Spain, France, and Germany, and most of the other European countries, even Italy, was in 2007, when publicity for lawyers were permitted by law. But things have been changing, apart from the competition law and competition authorities that wants a free competition in the market, because of the European Union. And with the Bolkestein Directive, what member states had the duty to do were to remove all the obstacles, not only for consumers, but also for providers of services and professionals, to remove all the obstacles to make a real single market, which means to have free provision, free services, and free establishment. And this duty, the European Union member states had the duty to do it by 2010. With this directive, Bolkestein, what we call Bolkestein because it was Fritz Bolkestein, the commissioner, that took it in advance, the aim was really the goal was to get a real market, a real single market with no borders, with free establishment, with free provision, and even with free diploma, free qualification. Now we have right now, and developing in all those legal systems in all the European member countries, the European qualification framework, which means that a lawyer will be a lawyer in Spain, a lawyer in Turkey, a lawyer in Italy, which now is quite different from country to country. Secondly, this directive, the Bolkestein one, wants to guarantee the legal security not only for the professionals providing the services, but especially for consumers. So everything is focused to consumers. That will let us understand why we have our profession is not so self-regulated, but regulated only by the law. This directive lets the chance also for professionals to establish in any other country of the Union where they are not being obtained the diploma, but obtaining it in each own country. How Bolkestein has been achieved by 2010? Well, especially applicating the principle of the origin country where to apply the law. The right of the citizens to get services provided all over the European Union, to develop a mechanism of mutual trust and mutual recognition within the European Union member states, and especially promoting a code of conduct for all European lawyers, so will be the only system to achieve this only market. Apart from that, this directive has introduced some restrictions in legal profession where we weren't used to. But with the restrictions, also permissions. So we are now able to advertise and to have publicity of our own activity, personal publicity especially. We are able to, or this directive promotes a multidisciplinary professions within the lawyer or the legal profession. We can, in Spain, for example, be with economists and some other professionals around the legal system, the legal services providing. Free fees have arrived. No national or local bar can implement fees for lawyers. They are free. Services visa are only being implemented by law, but not by national councils or local bars. We have to be transparent with our annual memory of our activities, our members, what are they doing, or which kind of responsible liability insurance we have, etc. Everything's been focused on the consumer and his information, and to know who is trying to contract, because at least, although the contract between a client and a lawyer is based in the trust, is also a service contract. The first, regarding the promotion of just a code of conduct only for all Europe, we have to mention the CCB Code of Conduct and Ethics in one from 1988. In that moment, the CCB Code of Conduct was devoted of the personal publicity of the lawyers. But in those days, there were the days of the development of the e-commerce directive. The code operated only as a conflict of law provision rather than to submit a rule of submission of law. Conflict of law was applied always for the host country, so a lawyer practicing or having some court trial in another member state was subject to its own disciplinary or ethic code of their own country. Advertising in 1988, beyond the CCB code, was legal advertising by lawyers or attorneys at law and law firms, and it was only submitted to personal publicity. It covers publicity by firms of lawyers as opposed to corporate publicity. It means that council bars or local bars could only make publicized, organized only for the whole members, but not for one of each member, only to the whole profession. Under the Bolkestein Directive, reached 2010, personal publicity is absolutely permitted, personal publicity and also advertisement, and also the European Union state members should have the duty to remove all the obstacles that avoid this free right, or this right that is being implemented by this directive. A lawyer, as Maria said, is entitled to inform the public about his services provided, which means dedicate preference in an area of law litigation, where the address, or at least the professional address is, who is him, where did he get the diploma, experience, curriculum vitae, all these kinds that Maria said, and I don't want to say it again because it's late, we are few, and we want to leave. I mean, about every private and personal publicity, everything is possible. But as she said, it's very important that this personal publicity can be through electronic communication, which also the state members of the European Union had the duty to remove the obstacles to avoid electronic commercial communications through television, through radio, and of course all this. Who's going to deny that being a lecturer is not in a local bar or in a council bar or in any seminar is not promotion? Who's going to deny that getting into television or into a radio program is not promotion of a lawyer itself or himself? And this is also permitted. The only limitations, at least in Spain, because all the limitations regarding publicity are being removed, we are only regarding to the general publicity law for all kinds of services and professionals, and it's got to be real information. This is the only limitation. It mustn't be false, and it cannot be misleading. These are the only restrictions that Spaniards have regarding our profession, and in fact regarding any profession in Spain or provider of services, because our limits are in this law. And the only publicity forbidden is the misleading one and the false one. And regarding our profession, our limits is that we have to respect the fundamental values of our profession regarding the conflict of interest, professional secrecy, independence, etc. But we have no other limits. It doesn't mean, though, that we can be into a legal marketing, which means something different than publicity. But for publicity is aimed at informing to the public, to the consumer, which is trying to be protected by these services, by this directive, of the services that lawyers can offer than the marketing of legal services focused to consumers. Everything's been said. I think there's no more to add, because publicity and advertise is what it is. And thank you very much for listening and for inviting me again.
Biz kendilerine teşekkür ederiz. Özellikle çok kısa bir zamanda bu kadar önemli bir konuyu bu kadar öz bir şekilde bize sundukları için. Şimdi sorularınız varsa onları alacağım. Bölüm. Bir dakika yalnız. Mikrofonu alınız ve kendinizi takdim ediniz. Ve sorunuzu kime yönlendiriyorsanız onu da belirtiniz.
I'm Eli Christova from Bulgarian bar. I would like to ask both lecturers if in your countries there are disciplinary trials connected with the violations with the rules of the advertisement, and if so, are some lawyers prevented from exercising the legal profession because of that violations? Yes, thank you very much.
Preparing myself to this presentation, I checked it and I asked people responsible in our bar to provide me with the statistics of the disciplinary matters. And can you imagine that there are not at all disciplinary matters in this aspect? It means that lawyers feel their dignity and they do not violate the rules provided. There were some discussions about rankings that maybe it was not always kept our resolution, but in general there are not violations. I heard about one of the law firms, and it was just about having the disciplinary case. They called themselves, as the name would be in English, connections, which could be like for the law firm suggesting something that they may have connections, maybe with judges, maybe with some other authorities. And obviously it was criticized and they changed this name. But official, no cases in disciplinary. Thank you.
Regarding the state...
Siz, Sayın İsa.
Regarding to Spain, there are no cases because we can even offer prices. We can go on press, on media, and say, well, for a divorce, our price is 300 euros, and that's all. I mean, we can do anything, which 10, 20 years ago were no way. So there are no cases really at all. Further than competition authorities, the competition, but no cases at all.
İki konuşmacımız da gerçekten iki mutlu ülkede yaşıyorlar bu konuda. Bizde ise oldukça çok sayıda disiplin olayı var. Buyurun.
Avukatlar Özdil Ankara Barosu, medyatik davalarının katkım olmaksa medyaya intikal etmesi halinde bir reklam yasağına girer değil. Bir de medyadaki bir şeyin ilgilinin ana davayla ilgili bir soru yöneltmesi halinde bu davayla ilgili soruya cevap vermem reklam yasağına girer bilmez ki her iki konuşması da beni aydınlatırsa memnun olur.
Buyurun, Sayın Slazar.
Yes, I think that if the certain case run by the lawyer comes to media, and then the lawyer should inform only, and the lawyer is interviewed in this case, the lawyer should limit himself only to the facts and obviously without violation of professional secrecy regarding it, but not to use this occasion as the occasion for promoting himself and also talking about some other issues. It is very, very strictly set in our rules to limit yourself to facts, but also remember about the professional secrecy.
Evet, Sayın.
Well, in fact, it's the same because lawyers in Spain have to respect the principle of professional secrecy and independence. But As I said, we have a very, I don't know if in Turkey is just arrived, but we had a terrible scandal about Palau de la Música and Millet case, people going to jail because manslaughtering and everything. A very terrific scandal. And obviously the criminal lawyer that is covering with this case has been appearing in the press and in the media and on television regarding that case, but obviously next manslaughtering man, very important man in Catalonia, in Barcelona, will go to this lawyer because he's doing it very well. At least this is promotion also. I mean, the limit is quite huge, but it's promotion. Legal promotion.
If I may add something, this is promotion by the fact being good, but not misusing the promotion, the situation. If you are good, you are good, and then people come to you. This is the fact.
Yeah, but media helps it. Helps this promotion, I think so.
Chiroulis, Second Vice President of the CCB. I'd like to add to the excellent speeches by the two ladies that the rule of the CCB is like a Bible because it protects, on one hand, the lawyer. He can publicize his details, at the same time is compelled to observe certain rules. And the latest directive, which was referred to as the Bolkestein, that's the directive of 2005, talks about, encourages or asks all the member states to remove the absolute prohibition. But at the same time, it recognizes that the bars, that the member states can, in respect of the regulated professions, that is lawyers, can still put prohibitions in order to protect the professional secrecy and the core values of the profession. Therefore, each bar can still protect its traditions, the core values of the profession. You cannot say, like in the old days, in Greece, in Turkey, in Poland, Spain, Italy and Austria especially, advertising is forbidden. And instead we're using the word publicizing information. But you can prohibit advertising if you say that I'm better lawyer than Maria or Maria is better than me. And also, as far as I know, in Greece there have been many cases of discipline where people were advertising unprofessionally by going every day on television and pretending they have a case, and they have been referred to the disciplinary board for that and punished.
Katkıları için Sayın Evangelos Tsuroulis, bilmiyorum doğru mu telaffuz ettim, teşekkür ediyorum. Başka, buyurun efendim.
Ankara Uluslararası Avukatlar'dan Sezai Aydıner. Her iki konuşmacıya da bu doyurucu tebliğlerinden dolayı öncelikle teşekkür ediyoruz. Sormak istediğim şu husus, reklam diyoruz yasak ama tanıtım yasak değil. Reklamın içinde tanıtma kavramı ne derece sınırları belirgin? Çünkü tanıtmak, kendimizi tanıtmak istediğimiz zaman otomatikman bu bir nevi reklam olmayacak mıdır? Bunun sınırında bir kural var mı? Yorum farklılıkları nedeniyle barolarımızın disiplin kurullarında yer alınabilme riski nedir? Onu açıklayabilirsek biraz daha teşekkür ediyoruz.
Buyurun,
Yes, I think that we shouldn't use even three words, advertisement, promotion and information, because I really feel it as the information, and the issue is whether in certain countries this information is limited to some information, or it can be, because in case of Poland, those professions, they can inform the clients about their services. But in case of legal advisors, you have unclosed, open list of you have only the examples, what information you can use. But in case of other profession, we have the closed list of what you can say about yourself, about your services. I think that what both of us said, that limits for this info, whatever we will call it, advertisement or information, limits are put by our core values, by our dignity, but the image of our profession, what we feel which differs us from the other entrepreneurs. Then, if we will remember what I tried to point it out at the beginning of my presentation, if we will remember about the core values of the profession, promoting ourselves, informing about our services, we are not in danger. We will not violate the principles of advertisement, which are not only to us, which are to all entrepreneurs. You cannot evaluate comparing yourself with somebody else and so on. So just remember about core values of the profession, promoting yourself, and then I think we are not in danger. Thank you.
Ankara Bölüm Avukatlarından Kemal Hakimoğlu. Ben de sayın konuşmacılara teşekkür ediyorum. Özel bir sorum olacak. Özellikle tabela, kart vizit, logo gibi kullanılan tanıtım araçlarında sınır İspanya ve Polonya ölçeğinde soruyorum öncelikle. Sonra Avrupa ölçeğinde çok katı kurallar var mı? Örnek vermek istiyorum. Türkiye'de siyah ve beyaz rengin dışında tabela kullanamazsınız. Işıklı ve renkli tabela yasaktır. Kart vizitinizde filan davalar takip edilir veya yüksek mahkeme avukatı şeklinde ünvan kullanamazsınız. Logolarda kendi baronunuzun dışındaki bir logoyu kullanamazsınız. Katı sınırlar var. Şimdi bu reklamla tanıtım arasındaki, tabii inceliğe gene benden önce soruyu soran sayın meslektaşımın sorduğu soruyla da alakalı, bizdeki kurallar bu denli katı. İspanya ve Polonya özelinde böyle katı mıdır? Diğer Avrupa Birliği ülkelerinde de nasıl uygulanıyor? Bu konuyu sormak isterdim. Teşekkür ederim.
Önce Sayın Sözer.
Well, in Spain, we have forbidden to use the logo of the bar, but we can use any logo being registered, obviously, and you can use everything. But the local bar or council bar logo, which is of the council bar and the bar from the local bar. And with respect promotion and advertising that you were asking, well, in Spain we can even promote and advertise both. But as Maria said, and I think I said so also, always with the respect of our profession, which mainly are professional secrecy. It means that you can appear in the media mass, in the press, in the television, but not talking about other clients or other cases, something like that. You cannot even compare prices, but although in Spain now the publicity law permits, for example, one Coca-Cola to be compared with Pepsi-Cola, even with prices, you can even name both products. We couldn't do it because our fees are also free, but we can even appear in the media saying, well, I'll get you a divorce for only 200 euros, when everybody knows that in the market, the prices of the market are maybe 2,000, 3,000 euros for a divorce, a very simple divorce in Barcelona. But we can promote and we can publicize, always with the respect of the core values of the profession. Although, in another case, we get into the disciplinary board of our local bar or the national one, but even you can go to a trial because another lawyer can be offended by it.
Yes, I would like to inform you how it is in Poland. As regards the boards, just like to mark your law firm, there are very strict rules, and we are told that we should hang on the premises, on the wall of the premises, the sign that this is the law office, and it has been said in our principles what text should be placed there, and also the colors of this, blue and white, because we have our gowns with, with ties which are blue, and even the size of it is strictly indicated by our bar. This as regards the boards, and then as regards business cards, there are not any special restrictions, but obviously those business cards, as anything else, should be adequate to our profession, to our image. It cannot be something stupid, like stupid pictures or something like that. But there are no any restrictions in our code of conduct on this issue, on the issue of business cards. And if you have the offices, your law office will have branches all over the country, for example, branch offices, then all these branch offices should be also marked with this board as I described. Thank you.
Evet, teşekkürler. Başka soru yok anlaşılan. Konumuzun yetkin ve saygın konuşmacılarımızın görüş ve düşünceleriyle zenginleşen bu etkinliğimizin avukatlık mesleğimize olumlu katkılar sunacağına inanıyorum. Bunu sağlayan konuşmacılara ve günün geç saatinde bizi sabır ve dikkatle izleyen sizlere teşekkürlerimi ve en iyi dileklerimi sunarak oturumu kapatıyorum.
Tüm değerli konuşmacılarımıza ve siz değerli misafirlerimize teşekkür ederiz. Şimdi konuşmacılarımıza birer adet plaket sunmak üzere Türkiye Barolar Birliği Başkanı Sayın Vedat Ahsen Coşar'ı sahneye davet ediyorum efendim. Sayın Berra Besler'i de buraya davet ediyorum efendim. Sayın Evangelos Tusuradis ve Sayın Andre Karta'yı da sahneye davet ediyorum.